Hi all, this is attorney Maria Baler with the law firm of Samuel, Sayward & Baler in Dedham, Massachusetts, where we focus our practice in the areas of estate planning, elder law, estate and trust administration. Today I want to talk a little bit about selling your home when it's not owned in your individual name. There are all kinds of ways that people might own their property, and the way you own your property really dictates what happens to the sale proceeds when the house is sold. If you own your house in a revocable trust, then the proceeds belong to you. And although you would sign a deed as trustee of the trust and deposit the proceeds into a trust account, you can use the sale proceeds as you wish, to go on a spending spree, to take a vacation, to buy a new house, whatever you want to do. If your house is owned in an irrevocable trust, that's a different story. Irrevocable trusts are generally used to protect the home or other assets from having to be spent down on long-term care, or perhaps to shelter the assets from estate taxes at your death. This means that those assets really don't belong to you anymore. So when the house is sold, the deed will be signed by the trustee of the irrevocable trust. Even if you're a beneficiary of that trust in some way, for example, the trust might say you can receive the income from the trust assets during your lifetime. Even if you're a beneficiary, that does not mean you have the right to the proceeds from the sale of real estate that may be held by the irrevocable trust. The sale proceeds need to go into an account in the name of the trust, and then your access to those proceeds or how they can be used for your benefit is dictated precisely by the terms of that trust. And the trustee of that trust, who is probably not you, can only use those proceeds for your benefit in the ways that the trust permits. So like I said, you might be able to receive the income that the money is generating, whether it's in a bank account and it's generating interest, or it's invested in the stock market and it's generating dividends. The trustee may also be able to use the proceeds to purchase a new home for you to live in, but that home would be owned by the trust, just like the old home was, and not by you individually. There are no circumstances under which any sale proceeds should be deposited into your bank account. So be very careful about that if you're selling a home from an irrevocable trust. Sometimes our clients own a life estate in their house, which means that they have conveyed their house to a third party, usually to children, and reserved a life estate interest in the property. Again, this is typically done for long-term care planning purposes. When you own a life estate interest and the house is sold, things get really interesting. The IRS has actuarial tables that tell us how the proceeds from the sale need to be apportioned between the person who owns the life estate interest and the children who own what we call the remainder interest in the property. And how large the life estate interest holders' percentage is dictated by how old they are. So if you sell your house for $100,000 and you own a life estate interest in the property and you're, let's say, 80 years old, your life estate interest may be worth, according to the IRS, 20%. Means you would get $20,000 of the $100,000 sale proceeds, and the holders of the remainder interest, who might be your children, would get the other $80,000. And you could deposit your portion of the sale proceeds into your bank account. Your children would receive their portion of the sale proceeds to do with what they wanted. And even though you might wish and hope that they would use that money for your benefit or to help you buy a new property, there's no legal obligation for them to do that. Another important point to consider when you're selling your house are the income tax and capital gain tax implications of the sale, which are very different if it's a revocable trust versus an irrevocable trust versus a life estate transfer. And this is a little bit beyond the scope of our video today, but what I would say is, before you decide to sell a property, especially if it's owned by an irrevocable trust or a life estate, make sure you have a conversation with your attorney or your accountant about what the tax implications are going to be, both to you, to the trust, to the remainder holders if you have a life estate deed, just so everybody is clear on the tax implications, what tax they may have to pay, how that might impact the sale price, and how that will impact the funds that remain after the sale for your future use. Those are all very important things to take into account before you decide even whether or not to sell the property. And it's unfortunately sometimes a surprise to people when they don't explore those things until after the property is under agreement or after it's been sold. I hope this has given you some useful information about selling property that's not owned in your individual name. If you have further questions about this, please feel free to give us a call. We're always happy to help. You can also visit our website at ssbllc.com for more information and more videos like this. Thanks. Have a great day.